Hi everyone, this is a Barclay Damon live broadcast where we discuss all things L&E, labor, and employment. I'm Ari, let's dig in. Hey guys, welcome back. Welcome to Explaining the Requirements of the New York HERO Act. This week we are going to tell you everything you need to know about the New York Health and Essential Rights Act, or HERO Act. And today joining us, I'm very excited to introduce Brienna Christiano. Bree is an associate in our Albany office, and she also works with me in the Labor and Employment Practice Group. One fun fact about Bree is that she and I actually went to law school together. We both graduated from Albany Law back in the day. So shout out to ALS. Bree, thanks for joining us. Welcome.
Thank you for having me.
Of course. So just a little bit of general information before we, dig into the specifics. And I wanted to let our viewers know, if the HERO Act applies to you, you kind of already know the drill. It's been in effect for a couple months, and there's definitely some very specific requirements. It can definitely be a little complicated, but I think today, Bree and I are just going to give a more high-level, general overview. So, the New York HERO Act originally was signed into law on May 5th, 2021. Our listeners probably know that it applies when there is a highly contagious communicable disease that presents a serious risk of public harm, and that is designated by the New York Commissioner of Health. And, recently the HERO Act was extended until February 15th. So, Bree, with that background, let's get into it. So, Bree, can you just tell us generally, what the HERO Act is?
So the HERO Act is a list of requirements, basically, that employers need to implement and follow to deal with, for right now, COVID-19, but in other circumstances, potentially other highly contagious communicable diseases. New York State's been pretty clear that while this is right now applying to COVID-19, that this could potentially apply to other diseases in the future. But as you'll see, and you can note from some of the model plans that we'll talk about, everything is pretty tailored to COVID-19 and a lot of the exposure controls that we're used to living with at this point.
Yes, very good point, because obviously this is, I should have mentioned in the beginning of the episode, the next episode in our segment where we tell our employers, clients, everything they need to know about COVID-19. So we're talking about the HERO Act in the context of COVID, but as you point out, that's a really good point. This applies to anything that is designated as a highly contagious communicable disease. So Bree, it's my understanding that the HERO Act is really broken down into two sections. Is that right?
Yes. So there's two parts of the labor law that this entails. We have the first section, which is 218B, which is the occupational exposure to airborne infectious diseases. And this is the first part that went into effect last July.
Right.
And then later on, we have more specific regulations on workplace safety committees, which were proposed in December and are going to be open to public hearing. And so while we expect those regulations to look pretty similar to what we have right now, they are subject to change.
Right, Bree. So, yeah, in December, there were proposed regulations, and those were really based or applied to Section 2. So maybe let's definitely talk about that later in the episode, but let's focus on, Section 1, if you're okay with that.
Sure.
So Section 1, can you tell us a little bit about just the general requirements or generally what Section 1 of the HERO Act is all about?
Sure. So this applies to every employer. So we have anybody who is any person, business, entity who has employees who they exchange money for. I mean, it's very, very broad. The only exception to the definition of employer under the HERO Act is the state and any municipal entity. So they're exempted from complying with the HERO Act.
So this applies to, Bree, just to clarify for our listeners, like full-time, part-time, seasonal employees, are all of those counted toward, or I shouldn't say counted toward, covered by this section of the HERO Act?
Yeah, so with a lot of other New York State laws, we're used to, independent contractors or part-time or seasonal workers being exempted, but not in the case of the HERO Act. Temporary or seasonal workers, part-time employees, domestic workers, independent contractors, they all count as employees under the HERO Act.
Good point. Yeah, I think that's a really good point to make. So what are some of the specific requirements, Bree, or what does basically the HERO Act require of employers, at least Section 1 of the HERO Act?
So even before the HERO Act is activated by an airborne disease being designated by the Department of Health, employers have to adopt and implement an airborne infectious disease exposure plan. That plan has to be distributed to employees. This is done through either incorporating it into your employee handbook or attaching it as an appendix to your employee handbook. Either one is fine. You also have to post it in a visible and prominent location in your work site. You have to make it available and make it widely available. So any employee who loses their copy, give them another copy. And you also, once activation occurs, then there's a verbal review. The state doesn't require anything specific for a verbal review except for just going over the plan. And that can be done, via Zoom or whatever is appropriate at the time. But these things have to be done.
Understood. So maybe let's back up a little bit. Does the HERO Act define airborne infectious disease or give any guidance about what would qualify as an airborne infectious disease?
Yeah, for purposes of the HERO Act, you're always looking for what exactly the Department of Health designated as the highly communicable disease. And so that's going to be the touchstone. So in this case, the airborne infectious disease is COVID-19. And again, as we said earlier, that could change at some future point and be something different. But for right now, the HERO Act applies to COVID-19.
Perfect. And yeah, we talk about this on every episode, Bree, because, obviously us both being labor and employment lawyers, we know how quickly things can change. And, our listeners know we've had to record some updates for all of our episodes. So that's
Sure.
a good point to make. And it's not completely beyond the realm of possibilities that you and I will be recording an update to this episode.
Sure.
So yeah, I think that's a great summary, Bree. What I wanted to ask you, and I think this is important, or, our listeners would want to know, in terms of the plan that employers have to have, are there model plans available, like on the New York State websites, or what's the easiest way for an employer to kind of get their hands on a plan that they can use?
Yeah, so this is the best thing about the implementation of the HERO Act is that there's very, very thorough plans available on the New York State website. They're very easy to find. And there's a kind of a general model plan that you can really just go and fill in. There's blanks and things like that. There's also more industry specific plans available too. So you can look through those and determine whether your work site applies to kind of the generic model plan or whether, a industry specific plan would be more tailored to your work site. And in addition to that, you don't have to follow the model plan. You can make your own plan as well. But given that New York State has provided us these very thorough, easy to access plans, it's certainly recommendable to just pull one of those off of the website and use that and tailor it to your needs.
Right. And so I think one question that I know we've gotten a couple times is, I'm an employer and I go on the New York State DOL website and, I don't see an industry specific plan that, applies to my industry. So what do I do or what do I use?
Sure. And so that's when you can use either the one that's closest to your work site. So you can kind of look and say, well, it sort of applies to this plan the best, and then tailor it from there a little bit to match your work site. That's perfectly appropriate. Or in that case, if you really don't find one that fits, the general model plan is probably where you'd want to start off.
Right. And I think the guidance says that, for office areas or office work sites that, employers can use the non-industry specific plan that the state has on the website.
Yeah, exactly.
So I just wanted to talk generally, Bree, just high level, because I know these plans, I'm sure our listeners have looked at them. I know we've looked at them, and the plans can seem a little bit daunting. They're several pages long. There's a lot of info to fill out. Can you just kind of generally hit the high points for us about, what it should be included in the plan?
So the plan is generally going to include the kinds of controls we're used to in dealing with COVID. So for example, it includes mask wearing requirements. It has health screening requirements. It has hygiene requirements. The hygiene requirements are actually fairly specific, but they're all laid out in the plan. And so the nice thing is that the law is laid out in these plans pretty specifically. And so you can use that as a guidepost. But with regard to a lot of the requirements, the plan sort of refers to the Department of Health and the CDC for guidance. And so there aren't specific requirements. And so it could leave you with questions about, what are you supposed to do in your worksite because the model plan isn't particularly clear. But what you need to do in a lot of those circumstances is follow the CDC and Department of Health guidance, especially for things like mask wearing and stuff like that. The model plan is fairly clear that it refers to the CDC and the Department of Health.
That makes sense. And I'm sure, most of our listeners, especially those who have, manufacturing facilities and things like that, they probably know the drill, and they've been, following these guidelines right along with us for the almost 2 years now that we've been dealing with the pandemic. So I wanted to talk just briefly, Bree, before we transition to talking about Section 2 of the HERO Act, about, what happens when the Department of Health designates a highly communicable disease, and what does an employer have to do once that happens?
Sure. So this was very much the case over last summer. I'm sure you remember. We were told about the HERO Act. We were counseling our clients about the HERO Act and what it required. People were getting their plans together, and then at some point during that process, the governor announced that the Department of Health had designated COVID-19 as a highly contagious communicable disease.
Yes, we all remember.
And so it geared right up. And so in that case, what was required is that you had to take a look at your plan and make sure that the plan was compliant with the most recent guidance from the CDC and Department of Health. And as Ari knows better than almost anybody at this point, these things are constantly changing. And so a lot of these plans had to be adjusted and tweaked and things like that. And so once that happens and you have a final plan, that is when you do your verbal review of the plan. And so this does not have to be in any specific format. This can just be an informal meeting you have with your employees where you just run through the plan and things like that. And then certainly you have to provide a copy to each employee. And again, we talked about earlier, this is often done by either putting the plan in the employee handbook, or if you're not comfortable with that because this may not be in place forever, you can certainly attach it as an appendix to your employee handbook.
Understood. And I think the guidance from the state, New York State, basically says that when you provide an employee with a copy of the plan, it can be in English, but if your workers or an employee has a different primary language, you should try or strive to provide it in that other language.
Yeah, exactly. That's important.
Great. So I just wanted to verify, Bree, once the HERO Act requirements have been triggered. I know you talked a little bit before about the posting requirements. So basically, I just want to clarify for our listeners, the plan has to be posted in the workplace, right?
Right. This is going to be in a visible and prominent location. And that's the typical language the New York State uses for posting requirements. So you may just want to include it where your other New York State and federal postings are in your workplace. I understand that this is a little bit bigger, but somewhere where it's easy accessible and everybody can see it.
Understood. So Bree, you mentioned this briefly a few minutes ago, but I think it's important to clarify. So as it relates to having, the prevention plan in place, can you run through, timelines for that? And basically, I think what we're trying to get at is, if you're an employer and you're covered by the HERO Act, you really should have these plans in place already.
Sure. And so when this first rolled out, there were a lot of deadlines that gave employers quite a bit of time to get their exposure prevention plan in place and distribute it to their employees and do the verbal review. But those dates have come and gone. And so if you do not have your exposure prevention plan in place, or if one of the requirements hasn't been fulfilled, then we would recommend doing that as quick as you can so that you're complying with the HERO Act as it is currently.
Right. Makes sense. And as I mentioned, right in the beginning of the episode, the HERO Act was extended to February 15th, and we anticipate, I think, I don't know if you agree, but I think it probably will be extended again.
It seems likely to. I know that the governor has indicated that she's going to look at mask wearing again, and we don't know what that's going to do to the applicability of the HERO Act, but I think it seems like at least one more extension is certainly going to be appropriate.
Yes, and I did want to point out too, Bree, because I've had this question a couple of times. I don't know if you have, but basically, what's the interplay of the New York mask mandate and the HERO Act? And basically, the state has said, for purposes of the HERO Act, the New York mask mandate, which is basically an order, issued by the Commissioner of Health, is essentially guidance to the HERO Act. So, it's kind of, a lot of our clients have been like, well, what's the difference really? Or, we're already doing this. And I think our answers have been right. You're already doing it. Your employees are wearing masks. Keep doing it.
Right. So the model plan has a pretty specific rule about mask wearing, but it also refers to New York State and the CDC. Right. And so certainly the requirements under New York State law and the requirements of the CDC guidance are what you need to follow in the workplace.
Makes sense.
Hey guys, I'm coming in hot with a quick update for you on this. So if you're in New York, you already know that last week the New York State mask mandate expired and Governor Hochul did not extend that mandate. So if you're covered by the HERO Act, and Bree and I were just talking about it, you're probably wondered, what does this mean for you? On February 9th, 2022, the New York State Department of Labor actually updated its model exposure plan, specifically with respect to face coverings. And what the plan now says that, pursuant to CDC guidelines, face coverings in the workplace are recommended, but are not required. But I wanted to point out that with most COVID-related topics, just because the model plan has been updated to recommend masks does not mean that employers are not permitted to implement more restrictive means. So if you're covered by the HERO Act and you want to require face coverings in the workplace, you are permitted to do so. Just wanted to hit you guys with that quick update. Tune in for the rest of the episode. Thanks.
So before we jump into Section 2, Bree, I did want to just have you talk about for our listeners just a little bit about what penalties are associated with Section 1 and, what the penalties or damages are if an employer does not comply with the requirements.
Sure. So the HERO Act includes a provision that it permits the Department of Labor to investigate any violations and assess civil penalties against employers who are not complying with the HERO Act in some respect. So in any of the requirements that we've discussed today, they're not complying with some portion. And so they've noted that there can be a daily penalty assessed for failing to follow the exposure prevention plan. And also you can have bigger penalties, up to $10,000 even.
Right. I think that's important to know. And I think, Bree, and correct me if I'm wrong, but I think there also is a private right of action available, right?
Right. So an employee who puts the employer on notice that they feel that the employer is in some respect not following the HERO Act can bring a civil cause of action if the employer fails to remedy whatever the employee's complaint is. And so the employee has the ability to bring a private right of action and can get damages for that, attorney's fees, an injunction even. The employer does have the ability to obtain damages if it's found that the employee didn't have a meritorious action, but there is a risk there and certainly a high cost to that.
Yes. So our recommendation is get your plan in place and comply with the requirements of the HERO Act. So you don't have to deal with this, but we definitely want to, point it out for our listeners. And lastly, I think the law also does include an anti-retaliation provision, right?
Sure. So you can't retaliate against any employee for exercising any of the rights that they're entitled to under the HERO Act. So making complaints that the exposure prevention plans aren't being followed, or that the HERO Act isn't being followed in some way. Of course, that would look like a termination or, something like that would give rise to an inference that there was retaliation by the employer.
Yes. Well, I think, Bree, we did a pretty good job at giving a high-level view of, this Section 1 of the HERO Act, which, as you pointed out, really went into effect last year. So I'm thinking it's a good time for us to transition to Section 2, which, as you mentioned earlier, there were proposed rules that came out in December, and there's, a commentary period coming up. Can you tell us generally what, Section 2 is and what additional requirements there are for employers under Section 2?
Yeah, so Section 2 really deals with what they call joint labor management safety committees. We'll just refer to them as safety committees so that we don't have to,
Sounds
to
good.
keep saying that. But it has to do with an employer's obligation to permit employees who choose to write in and request to form a committee to do so. And there's quite a bit of very specific rules about how they're permitted to do so.
So one of the questions we've gotten a couple of times, Bree, and we'll definitely dig into the specifics in a minute, but one of the questions that I've gotten is, are employers required to have these safety committees, or are they mandated to under this provision?
An employer doesn't have any affirmative obligation to create a safety committee unless two employees or more write in and ask the employer to permit them to create a safety committee.
Understood. And I think it's kind of important to point out, one, it's not mandatory. And two, when I originally looked at the guidance, I saw that if you have more than one request from like two separate employees, like it doesn't have to be a joint request, then that's something that that's something that triggers these requirements.
Right. So, you could have 10 separate requests in writing, but it's going to be one committee in the way that the rules have intended it to be, no matter how many requests you get.
Makes sense. So Bree, what do the proposed regulations say about the, number of employees an employer has to have in order for Section 2 to apply, if anything?
So for Section 2, you have to have 10 or more employees for that to apply.
Understood. So I did want to point that out because I think it's a little more narrow than the broader definitions that we're dealing with in Section 1.
Yes, exactly.
So Bree, I wanted to ask you, if an employer receives a written request for a safety committee to be formed, is there any specific time frame that an employer has to respond, or what do these proposed regulations say about the time frame?
Yes, so it says that an employer has to respond with reasonable promptness, but it goes on to say that within 5 days, the employer has to provide notice to employees of the committee.
Okay. So basically with reasonable promptness, which I think like us in the legal world know that that's kind of like an amorphous
Sure.
concept. But it sounds like based on what the regs say, 5 days seems like a reasonable period based on the way they're drafted.
Yes, exactly. So you should be prepared to give notice to employees that the committee is going to be formed.
Makes sense. So, Bree, before we talk about, what the committee can actually do, I wanted to ask you whether the proposed regulations talk about, requirements for the composition of the committee, or, how many committee members there needs to be or there should be, things like that.
Yeah, there's very specific requirements for how the committee is composed. So it has to be composed of 2/3 of non-supervisory employees. And so a supervisory employee under the HERO Act is somebody who can direct and control employees, or somebody who can make changes to policies or rules or things like that on behalf of the employer. So we do not want those types of supervisory employees to compose most of the committee. It's going to be mostly non-supervisory employees. The committee is going to be co-chaired by one non-supervisory employee and an employer representative. So it's not entirely clear what an employer representative means, but it does not contain the designation of a supervisory employee, which is kind of interesting. But somebody who the employer chooses to have that co-chair responsibility. And as far as the size of the safety committees, it's going to be at least 12 members of the committee, or 1/3 of the total number of employees at the worksite, whichever number is fewer. And if you have less than 10 employees at the worksite, then it's going to be 3 representatives on the safety committee.
Got it. And we should point out for our listeners, Bree, that, we said earlier, that this section applies based on the proposed regulations to employers with 10 or more employees, but it seems like there's a little bit of a disconnect in the proposed regulations at this point, because there is a provision that provides for what to do if you have less than 10 employees and what the composition of that committee should look like. So I think this is a situation where, the rules are still being the regs are proposed at this point. So, I think important to point out to our listeners because it's not exactly crystal clear.
Right. Something that we've spoken about is that it probably has to do with the designation of multiple work sites on behalf of an employer. And so, these committees are either per work site or designated as, more than one work site, depending on the composition of the employer.
Right. So I think to our listeners, kind of stay tuned on this point and hopefully we'll get more clarification.
Sure.
So Bree, let's talk a little bit about, what a workplace safety committee is authorized to do under the proposed regulation. So what's the point? What can a workplace safety do under the law here?
Right. So the HERO Act, as it was originally written, didn't give any very strong parameters to what this committee could do. And so that was a little bit problematic in that it could, be a fairly powerful committee in the workplace. But now the law has been amended, and we know that the committees are authorized to raise health and safety concerns. They're permitted to review policies relating to occupational safety and health. They are allowed to review the adoption of policies in response to changes in safety laws and rules and regulations. They are also allowed to participate in any site visits by a governmental agency. And they're also allowed to review any reports that the employer writes to a government agency related to health and safety, which is still fairly broad. Yes. The regulations also give the committee authority to make their own bylaws for the committee and things like that.
Got it. So, definitely a little bit more involvement on the employee side as it relates to health and safety issues in the workplace as a result of Section 2 of the HERO Act, I would say. And I know you talked a little bit about voting. Bree, did the new regulations or proposed regulations say anything about meetings, like, the frequency or, whether they can occur during the normal workday or, what do the regulations tell us about the meetings of the Workplace Safety Committee?
So the Workplace Safety Committee can meet for up to 2 hours during the workday, once per quarter. So this is during paid work time, but the timing of the safety committee meetings cannot unreasonably conflict with the employer's business. So if there are other meetings that conflict, the safety committee is going to have to adjust to those employer business practices.
Yes. So I think it's good to point out to our listeners that it is, paid time, because I think that's definitely something employers need to keep in mind. And it's, definitely maybe a little bit different. Now, in that vein, Bree, did the proposed regulations say anything about like trainings for committee members or anything to that effect?
Yeah, there can be trainings of up to 4 hours of paid time per year. So again, the safety committee is able to train in up 10 trainings for that amount of time on an annual basis.
And what would be the subject of those trainings?
It would have to be related to the committee business, so health and safety concerns.
Makes sense. Like Section 1, Bree, I wanted to point out for our listeners, Section 2 does have an anti-retaliation provision, correct?
Yeah, employees are protected for reporting any violations or concerns. And again, retaliation looks the same under Section 2 as it does under Section 1. Any changes to the employee's position that could raise an inference that they were discriminated against or retaliated against for exercising their rights under the HERO Act.
Right. And I think what's important to point out about Section 2 is, a civil claim is available and liquidated damages are mandatory in the event an employee prevails in a civil claim. So, I think that's important to point out for our listeners because, if an employee prevails, then liquidated damages being mandatory, it's definitely a stricter or harsher penalty than under Section 1.
Yeah, the safety committee regulations are given quite a bit of leverage in terms of making the employers respond promptly to any request to join a committee and then follow through with the requirements therefore. And so it's going to be something that's very important for an employer to pay attention to once they get proper requests for an employee.
Yes, very good point. So, Bree, I think we did a pretty good job giving a high-level view of the HERO Act. Is there anything, different or wonky or anything you think we missed that you maybe want to tell our listeners about?
The thing with the HERO Act is that it's going to adjust very, very frequently. And so it's going to change based upon what the status of New York State and federal regulations are for mask wearing and social distancing and things like that. And it's also going to depend on the Department of Health continuing to designate COVID-19 as a highly contagious communicable disease. And so employers need to be checking in with that and making sure that the governor has announced the designation of the highly communicable disease. And so that's something important to watch. And just making sure that your model plan that you have is keeping up to date with all of these changes, which is going to be difficult, but is something that's going to be necessary under the rules.
Yes. And our listeners have heard us every week talk about how we need to all just pay really closely attention. You and I know it can be hard, just even being lawyers in this field, keeping up with things. So I think that's really good advice. And, we'll look out to see if the designation is extended again.
Yeah, exactly.
And we will do what we can to keep you updated. So thank you so much for listening, guys. We really appreciate it. Stay tuned. Next week, we're going to switch gears. We're going to leave COVID behind, at least for a little while, and we're going to start talking about pre-employment inquiries, interview questions, post-offer questions, what you need to know, what you can ask in the context of employee interviews, applications, and post-offer situations. So definitely stay tuned. You won't want to miss it. Bree, thank you so much for joining. I really appreciate it.
Thank you.
All right. Take care. The Labor Employment Podcast is available on barclaydamon.com, YouTube, LinkedIn, Apple Podcasts, Spotify, and Google Podcasts. Like, follow, share, and continue to listen. Thanks. This material is for informational purposes only and does not constitute legal advice or a legal opinion, and no attorney-client relationship has been established or implied. Thanks for listening.